In contrast to disparate treatment, now we're going to talk about disparate impact, or as I've said, I like to call it adverse impact, just to be able to better differentiate between the terminology. Disparate impact is looking at the discriminatory effect of a facially neutral policy on a Title VII group. For example, what it means is we can apply the same standard to everybody, and yet the standard tends to have a adverse impact or a differential impact on one group over another. So, for example, you could look at Exhibit 2.8, where there are some areas where we might see a disparate impact. So if somebody has an arrest record, that may be based on race. If someone has certain height and weight requirements, that may be an issue that has an adverse impact against national origin or gender. Educational requirements may also have an adverse impact against people based on race. Same thing for credit scores. The goal is that we want to be able to use a tool, but we need to check to see whether or not we may have an unintended impact on a protected group. Now, what great example of that was the Griggs versus Duke Power case. As you can see, it's mentioned at the bottom of the slide. In Griggs versus Duke Power, they changed their hiring policies to include a high school diploma. And when in fact Griggs was able to do the job very easily without a high school diploma, and what happened for Duke Power is their policy had an unintended impact on African Americans or Black Americans in that particular area because they were less likely to have a high school diploma. So we want to be careful about having criteria that may seem to be good, but may still have an adverse impact against groups of people. And we'll talk about what are the potential defenses that an employer can use in that case. So how do we use this concept to be able to make our case, our prima facie case for disparate impact? And obviously, for example, we may be using a screening device that is used to separate qualified candidates from candidates that are not qualified. One rule that we can use is the 4/5 rule, or what we call the flow statistics, how people flow into the company, and look at whether or not the minority group performs at least 80% of the majority group, at the rate of the majority group. And so if we're in a scenario where the hiring rate for the minority group is below that 4/5 threshold, then what it's telling us is there's very likely something involved that is having an unintended impact against that group, whatever that might be. Scenario 4 in your textbook gets at some of the nuanced issues around disparate impact. So if the requirement is not met, a presumption arises that the screening device has a disparate impact and must be shown to serve a legitimate business necessity. So what that means is if a company wants to defend itself against a charge of disparate impact, it has to show that there's business necessity involved, and that the criteria are job related. Companies run into the most problems with disparate impact when they're looking at screening tools and differentiating those they think should have the opportunity for additional opportunities for additional consideration, or not. And when we use subjective criteria in our screening methods, we're going to start to have problems with that. Pre-employment interviews can also be very touchy around issues of disparate impact, as well as some things that may be asked for or included on an employment application. So these are criteria that we should be very careful of, and we should be monitoring to see if we're having an unintended impact against groups of individuals. The business necessity defense is the way to go in terms of defending yourself against a disparate treatment case, as we said in the previous slide. the defense basically says that it is the employer's need for this policy or this particular screening tool or this particular skill set as a legitimate requirement for the job. And the employee can respond, as their rebuttal or rejoinder, as the proper term is. They can say less discriminatory alternatives to the screening device can and should be used. And so they would have to present a less discriminatory alternative for that. There were two key cases that really had an impact on defining disparate treatment and disparate impact. And the McDonnell Douglas Corporation v. Green is the premier case for determining what disparate treatment is. It defined prima facie case. It showed, the difference between having a legitimate non-discriminatory reason versus a BFOQ defense. And it helped us to define the pretext for intentional cases of disparate treatment. Griggs versus Duke Power, as I've already mentioned, is sort of the premier case for determining disparate impact. And it talks about, how do we make our prima facie case and allowing for business necessity defense as well as better alternatives. Other defenses. If the employer's evidence is not true, the claimant or the plaintiff has a burden of proof and persuasion to make the case. So it is important that if you're going to make a complaint, that you have evidence to show that you are, it is in fact true. The preponderance of evidence is the standard in civil cases. It's not, innocent until proven guilty, but it's the preponderance of the evidence. If the preponderance of the evidence indicates that discrimination occurred, then in fact, the courts can rule for that. The employer's bottom line, does it come out correctly? No. In key equal opportunity cases, it's not all equal numbers. There are some additional concepts that you should be aware of. Number one is the concept of what is considered a reasonable accommodation. The employer has a duty in some Title VII cases and ADA cases to seek to accommodate workplace conflicts. For example, we want to accommodate a disability up to a certain extent. It's limited by what is considered to be an undue hardship. And the challenge that we have with the ADA, of course, as we'll get into, is that what is considered an undue hardship for one employer is not necessarily an undue hardship for another. So a small business may have a lower threshold for what is considered to be undue hardship than a major corporation like AB InBev or Monsanto/Bayer. So it is important that we recognize undue hardship is not a hard and fast number or a hard and fast concept, but one that varies based on the context for each employer and each circumstance and accommodations being asked for. The extent of duty, for some of these things varies between religious and disability accommodations. So do we have a duty to accommodate religious differences? Absolutely. And how we make a reasonable accommodation to religious practices and religious beliefs is the key. Other things, exhaustion of administrative remedies, where basically that means all claims have to go through the EEOC process before you can file a lawsuit in court. All the claimants receive a right to sue letter if the case does not settle in agency. What this basically means is the EEOC reviews cases first. If they think that you have a legitimate case, but they're not interested in taking the lead on pursuing this in courts, they will give you a right to sue letter, in which case then you can then take it to your attorney and go to court, and you can file file to ask for remedies that way. Excuse me. Retaliation is the last thing. The employees claiming discrimination may file separate claims for negative consequences. Excuse me. Retaliation. Employees claiming discrimination might file separate claims for negative consequences experienced from employers for pursuing their lawful rights. So aside from the initial claims that can be made for discriminatory practices, an employee can also file for retaliation for somebody against an employer who may be retaliating against them for pursuing their right to sue. And I've had to do that myself, not in courts. I did it in an internal process in my organization, and I won my retaliation case very readily and very easily because I had it very well documented. I mean, that's really the issue here, right? On anything is, even if you remotely think that this might be a case, but you're not sure, it's important to document everything that you do. I've learned the hard way on that. So having good documentation, who was there, who experienced it, who witnessed it, who said what, why was it said, what was the threats, those sorts of things. It's very important to have it managed that way. There are a whole host of remedies that can come to an employee who has been found to be a victim of workplace discrimination. So what are some of those? Back pay, of course. Front pay, meaning pay that, is expected coming forward. Reinstatement if you lost your job. Seniority if you lost seniority in the process. Retroactive seniority, so your seniority is retroactive going back a few years because you didn't get the promotion that you expected to get. And injunctive relief, compensatory damages, punitive damages, we've already talked about both of those, attorney fees, and medical costs. So all of these are potential remedies that the courts can order for somebody who has been found to be a victim of workplace discrimination. The next two slides just get into further definitions of the terminology that we just saw in the previous slide. For example, what does back pay mean? What does front pay mean? And front pay basically means when you cannot be reinstated into a job, you can get front pay, which is getting at how much you would have made if you had been able to have your job reinstated. Retroactive seniority, again, also fairly straightforward. You get seniority back to the day where you were treated illegally. Same thing here, again, further defining what it means by make whole relief. And the goal of make whole relief is putting the claimant in a place where they would have been had there been no discrimination. So when we're talking about I'm going to make you whole, it means I'm going to put you at a place where even though you were affected by the circumstance, it doesn't affect your pay or position or things like that. So all of these, potential remedies are about helping to make someone whole, whether it's reinstating pay, reinstating them into a job, compensating them for their pain and suffering, et cetera, et cetera. There are a number of different places where you can get access to legal briefs. You don't have to go to a law library necessarily, but it's a good place to get it. LexisNexis is a great internet option. So all sorts of legal databases are available to you. They're all available to you in the SIUE library. We don't have a law library here, but there is one, I'm sure, in St. Louis University you may be able to get access to. And also there's the law school up in, I believe the law school's up in Springfield. If it's not in Springfield, it's in Carbondale. I don't recall. But you would get access to those law libraries. But there are also public ones too, so you may be able to just search online for whatever it is that you need. Here's a few management tips that you should be aware of in terms of how this stuff is framed with respect to our employment law toolkit. The courts generally allow employers to hire the best person for the job, and they have very broad discretion in being able to do that. It is important to avoid expensive mistakes in limited areas of prohibition. So that's why it is important for managers to be aware of what they can do and also what they should not be doing. So this way you can hire the best person for the job based on your criteria, but we want to make sure we're minimizing our risks and our legal liability. Transparency and safe communication of concerns promote preventative management. Prevention beats cure. So be transparent. Don't try to hide things. Don't try to use subterfuge. Be upfront and be forward about it. We know from research that the more transparent people are about decisions that they make and why they make them, the less likely they are to encounter issues of charges of discrimination if they're honest about mistakes and if they're transparent with people about the factors that go into making their decisions. Number 3, documentation and strong systems are useful in convincing a court or jury that an employer's actions were legitimate. So the employer is going to do well in terms of documentation and documenting what they've done, why they've done it. And the better the job you do it, the more likely you are to be able to defend yourself in a court of law. On the other hand, if you are the plaintiff, if you are the victim in this circumstance, it's absolutely important that you engage in your own documentation and make sure that you have absolutely documented all the events and who the witnesses are, because that will help make your case stronger as well. Number 4, retaliation against an employee for filing a claim is a separate offense. Avoid even the appearance of retaliation. So give somebody a wide berth. So not only would you then have the initial charges against you, but then retaliation charges on top of that. So they're completely separate offenses, and you need to make sure that you're not doing those behaviors. We want to review termination decisions internally, avoid unilateral or emotional decisions. And so if you're going to lay somebody off or if you're going to terminate somebody, make sure that there's more than one person involved in that decision. Make sure that you've got a 24-hour cooling off period, perhaps before you are able to submit the paperwork and make the decision to terminate somebody, because that cooling off period may help you to think better about how to frame what you want to do and why you want to do it. When you make firing decisions in the heat of the moment, that creates more of a problem for you, and it's less defensible in the court of law. Number 6, we want to be careful about managing layoffs. We want to make sure we document and prepare, communicate to people, show empathy, and show candor. Be honest and transparent with people. Let them know what's going on. The more that you hide things, the more it increases the likelihood that there may be accusations of discrimination that occurred. Number 7, train your employees to understand your policies and their rights. So part of what you need to do in your orientation program is make sure people are aware of what the policies are for how they work, and you should make them aware what their rights are, that they're allowed to organize, that they're allowed to submit claims against the company for discrimination, that they're allowed to be whistleblowers. If we don't do this, then again, we are doing our employees a disservice and we look like we have something to hide, which increases the likelihood we're going to get sued. Number 8, some claims will require seeking reasonable accommodations versus via an iterative process, which means what is considered to be reasonable may be a discussion that I'm going to make some recommendations and you're going to counteroffer and we're going to negotiate till we figure out what the right accommodation is so that it isn't an undue burden to the organization, but also continues to help the employee based on whatever accommodation needs to be made, whether it's religious or based on ability. Lastly, monitor policies for potential adverse impact and compliance issues and update always as needed. We should be regularly reviewing our policies and our hiring tools to see whether or not we are having an unintended impact against groups of individuals. So the more that we stay on top of that with the mindset that things change, things evolve, and we may need to make changes to our policies because of that, that's the goal. That would be the most important.